Fighting back. How to handle the narcissist in court. There is a good chance that you have either encountered your particular narcissist in a court setting or you will do. This is because of two factors, which are especially prevalent with our kind. One, our behavior results in the necessity of bringing court action. Two, our need to win prolongs such court action, necessitating a court hearing. Most people either avoid having themselves behave in a way which causes a legal action to occur in the first place, or if legal action occurs, they look to mediate and bring about a settlement without the necessity of a final court hearing. The three main arenas in which you will find a narcissist involved in a court hearing are as follows. 1. Proceedings involving children, whether it is proving parentage, addressing issues of residence or contact, and similar. 2. Criminal proceedings where the narcissist has committed a crime against you. 3. Proceedings involving property or money, usually divorce proceedings, but will also include proceedings for child support, the return of money or property owed, or you may even be on the receiving end of a claim brought by the narcissist. I am not referring in this article to the actual legal action itself. I have addressed that in the recording The Dirty Divorce, which gives you an insight as to how we approach the legal process. This recording is about what you can expect and what you should consider doing at a court hearing where we will be present. The first aspect of this is to understand our mindset. What do we want to achieve from this court hearing, and how do we regard this hearing? 1. As you would expect, we want fuel. We want fuel chiefly from you, whether you are angry, frustrated, or upset. But we also want to gain fuel from the lawyers, the judge, the jury, the reporters, the police, the probation service, the experts, and anybody else who happens to be in the courtroom. 2. The hearing is a stage for us. We are the main attraction, and as a consequence we regard this as an opportunity for us to make it all about us. This means that we will draw attention to ourselves. We will pass comment repeatedly about what is being said, even though it is not necessary or appropriate for us to speak. We will engage in exaggerated gestures to draw attention to ourselves, head shaking, nodding, waving our arms around, pointing, and so on, even when we are not in the dock or giving evidence. 3. Exhibiting our usual contradictory behavior, we revel in the fact that we have been given a stage for the gathering of fuel, but we also resent the fact that we are having to appear in court. If we are taking action against you, we resent having to give up our time to do so. If we are defending a claim brought by you or involving you, then it is all your fault that we are facing this imposition on our freedom of activity. You are impinging on our sense of entitlement to do as we please. 4. We are here to win. We do not ordinarily engage in compromise unless doing so provides us with a further advantage. And therefore, we want to win by getting what we regard as ours, keeping what we regard as ours, defeating you, and escaping charges. Whatever the nature of this hearing, our intention is to win, because this accords with our sense of superiority. 5. We do not recognize the authority of anybody inside the courtroom, because we outrank them all. The judge is an idiot, the expert does not know what she is talking about. Your lawyer is a fool. Our lawyer is only good because we are his or her client. The jury consists of morons. The child psychologist is biased, and so on and so forth. We are doing everybody a huge favor by turning up at court. 6. We will not accept anything which goes against us. This is as a consequence of our sense of entitlement and also our inherent need to escape accountability. Any witness which gives evidence against us is a liar. Any ruling against us is biased. The expert which provides evidence against us is bent. The police officer who testifies against us is corrupt. And we can stand when we want, sit when we want, speak when we want, and we will argue with anybody and everybody who tries to shackle us in some way. 7. This hearing is a marvelous opportunity to provoke you, intimidate you, and punish you, and we will be looking to use this court hearing to achieve these things. Be in no doubt that the instigation of court proceedings against you is a hoover. Any court hearing, whether you started the legal process or not, is seen as an opportunity to hoover you, because you are there. You have entered our sphere of influence, so there is a hoover trigger. We know there is fuel on offer because of the heightened emotional nature of a court hearing, and we have a direct means of engaging with you. Thus, the bar is lowered on the Hoover execution criteria. Accordingly, we will want to engage with you, and we will keep trying throughout the hearing. We will stare at you, try to speak to you, goad you, make comments when you are giving evidence, gesture at you, and engage in any action which allows us to interface with you in order to draw fuel. It is worth explaining how the three schools of narcissism will generally behave, so you can factor this into your considerations. The lesser narcissist will not be able to keep his fury under control. He will engage in frequent outbursts, threats, and protestations. This means his lawyer, if he has one, will be tasked with trying to calm him down. There are likely to be frequent adjournments, continuances, to allow the overheated lesser to cool down for 10 minutes or so, and the smooth running of the hearing will become fractured. Do not be surprised if a brawl breaks out and the lesser is held in contempt of court and removed from the courtroom. The mid-range narcissist will see this as an opportunity to provide an Oscar-worthy performance, as if she is starring in a Shakespearean tragedy. Frequent pity plays, turning on the waterworks, fluttering of eyelashes, dramatic pauses, feigned fainting fits, requests for adjournment so she can compose herself, asking for a glass of water, and so on. All attention-seeking, all designed to delay and garner sympathy from all of those in the courtroom. Most of all, designed to test your patience, because you have seen it all before, and you can see through it. The greater narcissist poses the most significant problem for you, albeit you are far less likely to have been ensnared by one, since the lesser and mid-range narcissists are far more common. The greater narcissist, having a far more scheming mind, greater levels of control, and a Machiavellian mind, will apply considerable manipulation in order to secure the win for himself, and therefore his approach will be more subtle, more effective, and harder to displace. Knowing our mindset and how we approach the court hearing, what should you do? 1. Ensure your lawyer, if you are using one, fully understands narcissistic personality disorder and has dealt with our kind previously. This is fundamental. If you do not only do you run the risk of not being believed by your own lawyer, and probably regarded as a fantasist, histrionic, and so on, he or she stands to be manipulated by us, so that they pressure you into accepting a situation which is less beneficial for you. Expect comments such as, "He seems like a decent enough chap and wants to put this behind him, so you might want to consider this new proposal." Or, "It is clearly upsetting her having to deal with this, so I should imagine we can get a settlement sooner rather than later." 2. Ensure anybody who is invited to conduct an assessment of the narcissist for the purpose of the court proceedings, for example, a court-appointed psychologist or a probation officer, understands what NPD is and has dealt with it before. Similar reasons to those advanced in my first point above are applicable to this as well. 3. Arrive at court early. Do this to ensure you are not arriving flustered, but also so you can secure a consultation room prior to court. In criminal proceedings, you may have victim support available to assist you in this regard, but in matrimonial, financial, and child applications, there is no guarantee of this. Securing a consultation room is very important. This is so you can have discussions with your own lawyer, etc. privately, but also because it creates a barrier between you and us. If you have to sit or stand in a public area, we will be hovering, trying to catch your eye. We will walk over and speak to you, we will stand nearby, and speak in a loud voice, cracking jokes, etc. to unnerve you. Get a consultation room, and sit with your back to the door, so that you cannot see us keep walking past through the window in the door, because we will do this. 4. Ensure you are prepared. Arriving early allows you to compose yourself, gather yourself, get your bearings, and ensure you are focused. This is especially important if you are representing yourself. We are more likely to try and wing things because of our expected right to win, owing to our sense of entitlement. 5. Do not expect our lawyer to see through us. They will have little idea what we are. They will be manipulated by us, and ultimately they are our hired gun. Accordingly, whilst it may seem that our lawyer is just as bad as us, keep in mind why this appears to be the case, and this will provide you with a degree of reassurance. 6. During the hearing, ensure as far as possible that there is somebody between you and us who will block a direct eye line. When we give evidence from the witness stand or appear in the dock, we will be eyeballing you in order to draw fuel. Do not look at us. Your ignoring of us will criticize us, wound us, and may cause an ignition of fury. An ignition of fury is likely to assist you, because in such a situation we are far more likely to lash out at other people, thus showing the true colours and inviting the disapproval of those in attendance. 7. Give us enough rope and all, save the most controlled creator, will hang themselves. Your aim is to bring about an ignition of fury. This should not be done by goading us, as this is fuel, but by ignoring us. This will wound us, and our need for fuel will mean that we will lash out at others. This might be arguing, shouting, insulting, being sulky, storming from the courtroom, and so forth. Whilst you will be explaining to the court about our unreasonable behaviour, the best thing to rely on is us exhibiting this bad behaviour ourselves. The best way is to cause the ignition of our fury. This will not take much with the lesser at all, and thus the court will be able to see our true colours in all their glory, which will damage our position and improve yours. 8. By comparison, we will be doing all we can to make you react and accord with the picture that we have painted you as, namely a liar, violent, unhinged, crazy, promiscuous, hot-tempered, and so on. Not only will your reactions give us fuel and tell us we can keep provoking you to get more, we are also damaging your prospects of success. We have always known how to draw a reaction from you, and we will be counting on doing this in this final court hearing. So prepare yourself and increase your resolve to give no reaction. No reaction means no fuel. No fuel weakens us. No fuel means we have to draw it elsewhere. No fuel increases the chances of your comments and actions wounding us, resulting in an ignition of fury. 9. When giving your evidence, do not look at us or our lawyer, but rather direct all your replies to the judge. Not only will this make you feel calmer, but it will criticize us because you are ignoring us. It also lessens the control we have over you, either direct or through our lawyer. 10. When giving evidence, do not challenge us or our lawyer with your own questions. That is not the time to do it. It will fuel us and also indicate to us that we are getting to you, which will encourage further provocation. 11. When giving your evidence or making submissions, do so in a fuel-free manner. Remember, we are just wanting to lap that fuel up. Therefore, you need to get your emotions under control. Deny that to us. 12. Ensure your lawyer understands that all discussions are lawyer to lawyer and take place outside of the consultation room. Your lawyer can then return to you and convey the upshot of those discussions. 13. Ensure you take a trusted friend with you who stays with you throughout and acts as a barrier should we try to speak to you, enter the consultation room, follow you to the toilets, cafeteria, and so on. 14. Always refuse any attempt we make to get you on your own by having a heart-to-heart to sort this out. This is just a ruse to isolate you and draw fuel from you. If you are not represented, use your trusted friend to convey messages so you keep a barrier between you and us. Your whole approach should be as if we do not actually exist. That way you will provide no fuel, feel less anxious, and you will cause criticism. 15. Be aware that we will use third parties to approach you and also turn up with lieutenants and coterie members in tow. They should also be ignored, not engaged with in the ways I have described. 16. Refresh your mind beforehand of all the forms of manipulation that we engage in so you know how to spot them when they are rolled out of court. 17. Do not give in unnecessarily just to make the matter go away. We are counting on that. The longer you stick to your guns, without being patently unreasonable as to what you wish to achieve, the more likely you are to cause us to erupt, which will either cause us to walk off, and thus matters are more likely to go against us. We lose interest in the process and agree to a deal. Be mindful you will have to enforce it, as we will not stick to it even if agreed, just to be able to go and do something else, or the eruption in itself will go against us in some way. 18. Be aware we will try to get messages to you to draw a reaction from you. This means passing notes, texting you, ringing you. You may consider it prudent to switch off your phone and organise for urgent messages to be sent to your lawyer, trusted friend instead. We may contact you through social media, through third parties, and even using the court tannoy under some pretext. 19. You will experience frustration with how we are behaving, whether it is milking the situation through pity plays, engaging in a character assassination when giving evidence, and/or asking questions, smearing you and raking up sensitive matters. This is all being done to provoke a reaction from you and gain fuel. Understand this will happen, and know it will feel unpleasant. Focus on keeping yourself fuel-free, which will aid your outcome. 20. The reason most court hearings have to go to a final hearing is as a consequence of the unreasonableness of one of the other parties. Otherwise, it will settle beforehand through agreement being reached. We of course revel in unreasonableness, owing to our sense of expectation, refusal to accept blame, and desire to draw fuel. There will be occasions where we can pull the wool over people's eyes and get the results we want, but this is usually because the non-narcissist has fallen into one of the traps I've described above and failed to maximize their chances. If you adhere to these points, the unreasonable position of the narcissist will eventually come to the fore and be rejected by a judge. 21. When leaving the court, wait for some time to ensure that we have left the vicinity. This also applies to lunchtime adjournments, as if we remain at liberty, we will be looking to pounce on you to draw fuel. This might be gloating if we have been successful, or to berate you if the hearing has gone against us. Be mindful of being ambushed by us in this manner. 22. Don't use social media to comment on the forthcoming court hearing, comment during it, or afterwards. This is likely to fuel this in some way, and may well invite a response from us or from our coterie. Knowing who you are dealing with, how we will seek to manipulate you, how we want to use the platform to gain fuel from you, and applying the above recommendations will serve you considerably well when you have a final court hearing involving our kind. Except, of course, when Judge Tudor is presiding.